Hey, Joe Zarzaur, here to give you an update on your case. If you're getting this video, that means that your case is going to litigation. And you may or may not remember, but when we first met, when you first met with me before your case even started, I told you that 90% of cases are able to be settled without having gone to court or going to litigation. Well, yours is part of the 10%, so congrats. I say that tongue in cheek, but it means basically we weren't able to settle your case prior to suit despite our best efforts. And we decided, after consulting with you, that it's in your best interest to file a lawsuit and go to court. Only 10% of cases go to court, but of the 10% that go to court, only about 1% actually go to trial. So just because your case is going to court does not mean that it's going to trial. So separate those two things from each other. Going to court with a piece of paper and filing a lawsuit is different from actually walking physically into a courtroom and having a trial. So the fact that you're going to court with your case does not mean that you're going to trial necessarily, because only 1% of the 10 that we file actually go to trial. Okay, so let's take that first. There are different phases of going to court. The first phase is where you basically trade papers. Okay, the lawyers trade papers. We first trade papers starting with the lawsuit, and then they have to file an answer. That takes around 40 to 60 days. I know this is not a quick process. I know it sounds like a long time. You've already waited a long time to get to this point. But it's not quick, okay? After we've traded papers, we basically have determined each other's positions, legal positions. Then there's a phase called the discovery phase, and that's where they basically kick the hubcaps of our case, and we kick the hubcaps of their case. And we ask them for documents, and they ask us for documents. We're going to be involving you in that process because that process involves you answering questions for us. The paralegals, the litigation paralegals who will be in touch with you and whose names are in this email, will be the ones that are going to be in constant touch with you about the different stages and obligations in this process. So don't worry, we'll walk you through all this. So there's the pleading stage, which is the stage where we do the lawsuit and the answer. There's the discovery stage where we trade papers and information. And there is the mediation. That's where everybody wants to know, when is my case going to be over at this point? After we finish the pleading stage and the discovery stage, which usually takes about 3 to 6 months, there's then an opportunity for us to mediate the case, which means we're all going to get together in a room and we're all going to go over what's going on with the case and whether there's a chance to settle it. That means everybody involved, the people we sued, the insurance company for them, you have to come. We have a referee who's called a mediator that comes, and we try to resolve the case. I'd say 75 to 80% of the cases that go to court end up settling at mediation or somewhere around that time. So that's the mediation part of the case, and that happens generally 6 to 8 months after the lawsuit is filed. If your case doesn't settle at mediation, that still doesn't mean it's going to court, as in it's going to trial. That just means you weren't able to settle it. We can settle the case at any point before the jury is basically in the courtroom with us. But if it goes past mediation, we're getting the case ready for trial at that point, and we're taking depositions. And those are sworn statements under oath that we generally take of your doctors, because we want to videotape those and show those to the jury for the doctors that can't come live to trial, and many of them cannot. So if the case gets past mediation and we're not able to settle it, then we get a trial date. You'll know the trial date in advance. We'll give you plenty of notice, and we'll set it off well enough in advance where you can make sure you're there for the entire time the trial is going on. Trials in typical car wreck cases take 2 to 3 days. Trials in medical malpractice cases take up to a week. But long and short of it is, most cases will actually end up settling before the even trial is here, okay? Or sometimes it settles on the eve of trial, which is the night or two before. But sometimes we're not able to settle the case and we actually go to trial. If that happens, we'll walk you through that process too. So don't worry, everything's going to be fine. We're here to guide you through the entire process. So anyway, this is the litigation phase of the case. Litigation includes the filing of papers, the trading of discovery, mediation, and ultimately all the pretrial depositions that have to be taken, and then ultimately the trial. So that's where we'll be with the case. You can contact us via the numbers that are in this email, the paralegal, the litigation paralegal. You can contact me directly at all times too if you have more pressing questions. But we're here to answer those questions. We're here to serve you. And we know that time is an issue for you, okay? We know you want this over with. We know you're already aggravated that it didn't get settled in the pre-suit phase. We're aware. And it's our job to get it done as quick as possible too. So you can find us on the web at zarzaurlaw.com. There's 12 different ways in this email to contact us. We look forward to working with you through the litigation phase of your case. Thank you.